Meanwhile, a US court ruled that Johnson & Johnson cannot use the bankruptcy of one of its subsidiaries as leverage to force thousands of cancer patients to withdraw their cases and accept a settlement offer.
Absolutely. Now, we've discussed this previously as well. The appeals court made it clear that a company must be in immediate, imminent and clear financial trouble before it can file for bankruptcy. Take a look at our next report for all the details on this.
Johnson & Johnson's baby powder and other talc items have been allegedly polluted with a harmful chemical which causes cancer. Several cancer victims filed cases against the firm. For over $100 million in damages, Johnson & Johnson has had to deal with lawsuits about the use of talc in some of its products. The company took all its talc products off the market in 2020, citing poor sales. Johnson & Johnson's attorneys estimate that as many as 100,000 claims relating to talc have been or will be brought against the firm. To settle those lawsuits and ring-fence its other products and offerings, Johnson & Johnson established its subsidiary LTL Management. In 2021, Johnson & Johnson offloaded its talc liabilities into LTL Management and immediately filed for bankruptcy protection for the subsidiary. The pharma giant's legal strategy was a deal worth $8.9 billion through LTL Management to settle those lawsuits. But many plaintiffs rejected Johnson & Johnson's offer and say the firm was trying to force them to accept the settlement by threatening bankruptcy. The bankruptcy lawsuit brought by Johnson & Johnson for its subsidiary has been rejected by federal courts for the second time in about 6 months. The company vowed to appeal the latest ruling. U.S. bankruptcy judge Michael Kaplan said that for the use of bankruptcy, a higher criteria is established by the court and rejected Johnson & Johnson's bankruptcy protection appeal. Judge Kaplan, referring to the reason for rejecting the appeal, wrote, and I quote, "As it stands now, engaging financial distress, observing smoke may not be enough. One must see the flames." Although Kaplan rejected Johnson & Johnson's case, he said he was still concerned by the backlog of lawsuits in the court system. He worries that cancer victims would have to wait longer for their cases to be heard. Moshi Maimon, a lawyer representing talc victims, said, and I quote, "It's a credit to the independence and integrity of our courts that a $500 billion corporate bully like Johnson & Johnson cannot escape to the bankruptcy court so as to avoid juries." Another lawyer fighting to have the second bankruptcy dismissed, Andy Bashfield, said, and I quote, "Johnson & Johnson sought the bankruptcy court's assistance in cramming that bad deal down on cancer victims. Thankfully, with the order, that ploy is dead." In response, Eric Haas, Johnson & Johnson's worldwide vice president of litigation, said in a statement, "As the bankruptcy court urged in its decision, we will continue to work with counsel representing claimants to pursue a resolution of the talc claims." Johnson & Johnson has insisted that its bankruptcy approach is meant to pay damage claims fairly and equitably. The firm has always maintained that its talc-based products are harmless, despite being the subject of several lawsuits.